Article 174 Argument Canon 2551 An argument is one or several connected postulations to influence the opinion of another upon faith or to support a proposition as proof. A postulation may be based on one or more facts, or suppositions, or a combination of both. Canon 2552 As all arguments depend upon meaning, all arguments are by definition fictional, regardless of whether they seek to influence upon faith, or proof or both. Canon 2553 The ability to present coherent and connected postulations is essential to any idea, model and system based on meaning. Therefore, the validity of an argument may be equated in some degree to the value and validity of model, idea or system. Canon 2554 As all arguments are by definition fictional, the test for the validity of any argument may be based upon such qualities as its coherence, comprehensiveness, relevance, consistency. The age of an argument, or its customary acceptance is insufficient evidence alone for its validity. Canon 2555 An argument that is consistent with these canons and conforms to the prescripts of pactum de singularis caelum is superior to any argument that is inconsistent to these canons. Article 175 Cause Canon 2556 A reason or cause is any alleged fact or facts consistent with natural law employed as an argument to justify and explain an action or act. Canon 2557 All divine immortal spirits expressed in trust to a flesh vessel possess the ability to reason, except those physically constrained by severe injury or disability. Where a man, or woman is unconstrained by severe injury, or disability, it is expected they accept self-determination and the exercise of reason. Canon 2558 The reason of the law ceasing, the law itself ceases. Canon 2559 No proceedings in law may commence without due cause. Article 176 Interpretation Canon 2560 Interpretation is the use of argument, reason, logic and competence in accordance with these canons to deduce the correct intent and meaning of the law. Thus, to interpret the law is to explain and apply the law as it was originally intended. Canon 2561 The best interpreter of a valid canon is the canon itself. Therefore, the best interpretation of any administrative act, statute or ordinance is its conformity to these canons first and secondly to itself. Canon 2562 Conformity to these valid canons, not use is the best interpreter of things. Therefore, custom alone is the worst interpreter of the law. Canon 2563 In the construction of valid agreements conforming to these canons, words are to be interpreted against the person using them. Canon 2564 Lawful commands in accordance with these canons receive a strict interpretation, but unlawful may command a broad and extended interpretation. Canon 2565 When anyone references, writes or speaks of interpretation, valid interpretation, or correct interpretation, it shall mean these canons and no other. Canon 2566 It is an invalid interpretation which corrupts the text of any canon. Article 177 Proposition Canon 2567 A proposition, also known as a protasis, is a form of words or symbolic variables by which an expression of meaning, also known as the predicate or premise, affirms or denies an assumption of fact concerning an object or concept, also known as the subject. The words or symbols used to construct and connect the expression between the predicate and subject are known as the copula. Canon 2568 The word proposition is derived from the Latin propositio meaning purpose or theme. However, the original ancient Greek word used by Aristotle when describing a proposition, in his invention of syllogism, was protasis from protasis, meaning to put forward, tender, to propose. Canon 2569 The word predicate is derived from the Latin praudico meaning to mention beforehand, to prearrange, to foretell, to warn. The word premise is derived from the Latin premissa meaning to send in advance. Canon 2570 The word subject is derived from the Latin subjecto meaning to lay under, put to throw up. Canon 2571 The word copula is derived from the Latin copula meaning rope. leash, grappling iron, anchor or binding. Canon 2572. In the context of logic and argument, the word sentence is wrongly argued as being equivalent to the word proposition. The word sentence is derived from the Latin word sententia, meaning way of thinking, opinion or sentiment. Therefore sentence by its original and true definition implies a predisposed bias towards an argument which is incompatible with the independent and objective testing for truth or falsity of an expression. Canon 2573. In the context of logic and argument, the word statement is wrongly argued as being equivalent to the word proposition. The word statement is derived from two Latin words statua, meaning to determine, appoint, to decide, settle, to decree, prescribe, to judge, consider, conclude, and ment is meaning mind. Therefore statement by its original and true definition implies a judgment or conclusion in mind before the facts have been tested on their merits, being incompatible with the concept of proposition. Article 178. Conclusion. Canon 2574. A conclusion, also known as a deduction, is a form of end, finish, result or decision derived through inference and the application of logic and reasoning. A conclusion is also the third proposition of a syllogism, deduced from two prior premises, major and minor. Canon 2575. The word conclusion is derived from the Latin concludo, meaning to shut up, to enclose, to end, to round off. Canon 2576. A form of end, finish, result or decision that is not derived through inference and the application of logic and reasoning cannot be defined as a valid conclusion. Canon 2577. All arguments as matters of law must be resolved through valid conclusion. Article 179. System. Canon 2578. A system is a set of interdependent and specialized objects or concepts that can be defined within some boundary as forming a unity, also known as an integrated whole. Canon 2579. All systems share the same elements, being I, rules of classification and behavior by which the system itself and its function may be defined, and 2, a boundary or limit which defines those objects or concepts within the system and those excluded from it, and 3, structure by which the objects or concepts exist and conform within the system, and 4, relationships between the various objects and concepts, and v, dynamic behavior and interactivity between the various objects and concepts, and vi, purpose for which the system primarily exists. Canon 2580. All forms of valid argument are derived from valid systems of argument. Canon 2581. All valid systems of argument may be divided into either bivalent or multivalent systems determined by the outputs of any given argument. Bivalent systems such as logic produce just two choices, being an A or B outcome. Multivalent systems such as most forms of natural systems produce more than two choices, such as an A and or B to some degree outcome. Canon 2582. All valid systems of argument may be defined by their influence on the conclusion of any propositions as either passive or active. Passive systems of argument seek to remove deliberate bias to enable the most objective conclusions from given inputs. Active systems of argument seek to impose certain bias to ensure the desired conclusion is achieved. Article 180. Validity. Canon 2583. Validity is the quality of a form being valid, namely strong, authentic and genuine. As such form is capable of being justified and proven to be true through logic and reason. Hence, valid arguments possess legal force. Canon 2584. An argument declared valid on claimed force of law alone does not make it valid. Not only must such a body of law itself be proven to be valid, but the arguments by which the law is used. Canon 2585. Valid is equivalent to testing and measurement. Validity is impossible without the existence of some objective measure. Canon 2586. Belief and faith are irrelevant to validity. Validity is a test of the strength of a form, not its popularity. The more comprehensive a model, the more logical, reasoned and perfected, the more valid, regardless of whether such a model of law is believed or not. Canon 2587. Any form of law based upon belief and faith that is tested against an equal or larger body of law based upon logic or reason, by definition is less valid. Canon 2588. In accordance with these canons and because of the existence of these canons, all Roman law of the Roman cult, also known as the Vatican, also known as the Roman Catholic Church, as well as Talmudic law and Sharia law, are henceforth invalid. Positive Law 181-190. Article 181. Maxim. Canon 2589. A maxim is a term used to describe a self-evident axiom or premise constituting an expression of a general principle or rule in accordance with these canons. Canon 2590. By definition, all valid canons that precede or follow this canon are maxims. Canon 2591. A maxim is not a maxim but an inferior statement or claim if it is not in accordance with these canons. Canon 2592. The claim a statement is a maxim through custom or acceptance has no validity unless it is in accordance with these canons. Therefore all claimed maxims of law are hereby null and void unless they conform to these canons. Canon 2593. No statement that is claimed as a maxim of law may be used in a competent forum unless it is a valid canon. Canon 2594. When anyone references, writes or speaks of a maxim, or maxim of law, or maxims, it shall mean these canons and no other. Article 182. Status. Canon 2595. Status is the legal standing and position of a person determined by their attributes, inherent rights or limitations, and the nature of the controversy as either criminal, civil or ecclesiastical. Canon 2596. By definition, a living member of one heaven possesses a minimum of three persons, being their divine person, true person and superior person, that all have higher status than any inferior Roman person or lesser society. Therefore, no Roman juridic society or any other non-Euclidean society may claim jurisdiction over one or more of the superior persons of a living member of one heaven. Canon 2597. When the offense is criminal or ecclesiastical in accordance with these canons, all members are subject to the law and equal before the law. Therefore, any claim of higher status above the law by a member is automatically null and void from the beginning, as well as a grave injury to the law and rule of law. Canon 2598. When the offense is civil in accordance with these canons, only juridic society persons may invoke those positions, limits and rights bestowed by their creation, including statutes, to support a claim of higher status. All other persons are equal before the law. Canon 2599. When the offense is issued by a Roman society or some lesser society against a member of one heaven, the member may evoke their superior standing and choose to have the matter resolved in accordance these canons. Article 183. Competency. Canon 2600. Competence is the fictional concept of being fit, proper and qualified to produce and argue reason through knowledge and skill of law, logic and rhetoric against opposing arguments. Therefore, a man or woman cannot claim competence without demonstrated skill at reason, argument and knowledge and suitable qualification. Competence may also be used in the context of juridic persons having sufficient authority and qualification within the limits of their statutes. Canon 2601. As the divine person is also part of the divine creator, a divine person is always considered competent. Canon 2602. While the divine person is always considered competent, it is possible for the true person represented by the flesh to be incompetent. Canon 2603. Only true persons represented by the flesh of a living man or woman demonstrating knowledge and consent to these canons and agreeing to obey statutes derived from the canons may be regarded as competent. Canon 2604. As natural birth of the flesh is proof of lawful conveyance from a divine trust to a true trust and willing consent by the divine person to be born in accordance with these canons, when the flesh denies its membership to one heaven, or its trusteeship or these canons, then the flesh automatically declares itself as incompetent. Canon 2605. An incompetent person is not permitted to hold any senior office, nor hold any ecclesiastical position for any entity which claims divine power and authority. Canon 2606. Any judge or magistrate who willfully and deliberately ignores their obligation to stand by their oath and duties of office, especially when requested to reaffirm their solemn obligations before or during a legal proceeding, automatically declares themselves incompetent with any subsequent judgment, orders or decisions null and void from the beginning.